Let's turn now to the settlement reached on the issue of school books in Nassau County. I'm joined by attorney Lauren Zimmerman, who led the lawsuit opposing book removals and also represented the authors of one of those targeted books. Good morning, Lauren. Thanks for being here today.
Morning. Thank you for having me.
Is this settlement a victory?
Yeah, I think it's a watershed moment in the battle against book censorship across the country and particularly in Florida.
So this is a agreement reached with the Nassau County School District. Tell us a little bit for people who aren't familiar. First of all, who are your clients? Who are you representing?
So, as mentioned, I was representing and continue to represent the authors of And Tango Makes Three, which is a widely lauded, critically acclaimed children's book that tells the true story of the two male penguins that lived in the Central Park Zoo a decade or two ago. And during their time there, formed an enduring pair bond and together raised, incubated, hatched, and raised a baby chick named Tango. And so my two clients are the authors of that book. One, Peter Parnell, is a very successful playwright, and the other, Justin Richardson, is a well-accomplished children's psychiatrist. And they wrote the book together. They live in New York City together. They're a married couple, and much like the penguins in the story, are raising their daughter together in the city. In addition to those.
Lauren, I think we've got you back, and I apologize for those technical difficulties. So you were telling us about your client, the authors and the illustrator of And Tango Makes Three. This book has not just been targeted in Florida or Nassau County, but in other places. And I think what's interesting is, it's a true story. It's not a fictional story about these two male penguins raising a chick. It actually happened at the Central Park Zoo.
That's right. Those two penguins, Roy and Silo, actually became national celebrities in our country when people learned about these two, I think they were termed at the time gay penguins that had formed this enduring pair bond in the Central Park Zoo and then together incubated and hatched and then raised their baby chick, which the zookeepers named Tango. People flocked from all over the country to come to the Central Park Zoo and see them. So the book is absolutely a true story, and it tells the story of how they developed their pair bond and then how they together, incubated and hatched and raised Tango.
So this lawsuit that you brought, it was a federal lawsuit challenging the removal of this book and other books from the shelves in Nassau County. It is a lawsuit that was predicated in part on your belief that the school district didn't follow its own procedure in removing the book. So tell us about what they were supposed to do, in your opinion, and what they actually did do.
Sure. So first off, there are certain laws that are in place in Florida that require when a school board or any sort of agent that they dispatch or committee that they dispatch take any sort of official action, and particularly with respect to book challenges, that they do so in public, that they notice and hold a public hearing where people from the community can come and weigh in and hear about what's happening. And of course, then the people making the decision can consider the community's views before making their decision. And here in that case, that didn't happen. All 36 books were removed behind closed doors. In fact, the decision wasn't even made public, or at least discovered, I think, until earlier this year when a local reporter reported on it. But people in the community didn't even know that these 36 books had been challenged and removed, restricted from the school library. In addition, the school board itself had a policy in place for certain steps that had to be taken in order for a book challenge to be lodged and considered. And its own policy wasn't followed in the process.
And so one of the claims that they made when you challenged specifically for this And Tango Makes Three, they said that it wasn't getting checked out as the reason why it was removed from the shelves. Is that right?
Yeah, so what was interesting is, it was a right-wing political group that challenged these 36 books, and the challenge lodged by that group was called Citizens Defending Freedom. All 36 books they challenged on the basis that they were obscene and were inappropriate as a result to be in the public school library. Now, again, all this was done behind closed doors, so I don't exactly know how this all came about, but 3 of the 36 books that were challenged on obscenity grounds, the defendants in our case determined were not obscene and shouldn't be removed, or didn't contain obscene material and should not be removed on that basis. But instead of just denying the challenge and saying, you put forth this particular basis and the basis isn't legitimate, they said, well, we're still going to remove these books based on lack of circulation or reading, basically alleging that the books, weren't being checked out at all and therefore need to be removed. But when we issued several public information requests, it turned out that each of the 3 books had been being checked out in the last 5 years, and in a lot of instances, far more than other books in the library that had never been checked out at all, and yet still remained in the library.
And so that claim was just false?
I guess the term that I would use is that the claim was pretextual, right? We allege that they, based on animus, based on the challenge, they wanted to remove the books. And so the basis that they provided for the removal was pretextual, was not supportable, and not accurate. But it was what they used to explain their actions.
So I know you say that this happened out of the sunshine, maybe not with public awareness. I think that, we could say that there are parents who in good faith are concerned about what their kids are consuming or reading. And, in Florida particularly, there's been this big push for more parental involvement. Is that a sense that you have of what happened, that this was a parent-driven conversation that was happening at the grassroots level in Nassau County?
I have no indication of that. As I mentioned, the 36 challenges were lodged by a national, anti-LGBTQ right-wing group. The person who lodged the challenges, my understanding, doesn't even have a child in the school district. And so, as far as I know, there was no community concern regarding these 36 books. Instead, a public interest group decided that its views on what our children should be exposed to and what they should be able to choose to read, because remember, these are optional materials in the library. This group feels that it should be the one making that decision.
If you're just joining us, we are talking with Laura Zimmerman. She is the attorney representing the authors and parents who objected to books being removed in Nassau County. You can join our conversation. Give us a call at 904-549-2937. You can also email firstcoastconnect@wjct.org or reach out on social media. We have a call from Charles on the West Side. Good morning, Charles. Go ahead.
Good morning. Laura, I read an article in the Times-Union yesterday that in Texas, I guess the same group of book banners possibly is trying to get the same books that they're trying to keep out of the schools out of the public libraries in Texas. Are we prepared for a movement like that here in Florida, or do you think you could see it here?
Good question, Charles. Lauren.
So what I will say, and hello, Charles, is that challenges to public library books, not just school library books, have happened in the country already. So I'm not surprised. Could that happen in Florida? Absolutely. Whether we're prepared, I can't answer that. I think it'll depend on the nature of the challenge, the district in which the challenge is brought, and of course, how the challenge is handled. A lot of these are very fact specific, and there are guardrails and rules that are in place to ensure that people's First Amendment rights are protected. And it's a question of whether people ultimately follow those rules to ensure that First Amendment rights are not infringed upon.
So, Lauren, tell us what this settlement actually provides for in terms of returning the books to the shelves, and what, if any, acknowledgments or concessions the school district itself made.
So the settlement restores to the public school libraries all 36 books that were challenged and removed or restricted. It restores Tango Makes Three back to its original condition, which meant that it was accessible to all ages and everyone in the library. And one of the statements that the defendants make in the settlement, which we think is very important, is that the book Tango Makes Three has pedagogical value, is appropriate for all ages, and contains absolutely no obscene material. With respect to the other 35 books, 22 of the books were restored back to their original condition, just as Tango, with respect to whatever accessibility aspects or characteristics they had before. The Perks of Being a Wallflower is also being returned, though before the book was challenged, it was available to kids in 8th grade and up. Now it's available to kids in 9th grade and up. And then there are 12 additional books that are being returned, but are also in parallel undergoing a review process. But in the meantime, those books are restored and may be viewed by any student who's 18 or over who has parental consent to check out the book.
So the school district did not acknowledge any wrongdoing in as part of this settlement. Is that right?
That's right. The settlement doesn't have any particular admission about liability.
And there's no financial claim that's involved here.
No, and I mean, the plaintiffs never sought any sort of financial gain here. This was always about their First Amendment rights and the First Amendment rights and, freedom of information for all students. There was no kind of financial incentive for anyone involved in this litigation on our side.
So tell us a little bit about your background. You're actually, you work in New York now as an attorney, but you're from Florida originally?
I am. I'm born and raised in Florida. I did all of my primary schooling in Florida, and the majority of my family still lives there. I began my legal career as a public defender in Brooklyn. So I feel innately I was trained to and have a strong sense of social justice and the protection of infringement of rights, particularly with respect to, underserved or minority groups. But since then, I clerked actually in the Southern District of Florida for a federal judge there, and then came to the firm that I'm at in New York called Selendy Gay, which is a litigation firm, and we handle a wide array of matters, anything regarding litigation, so any sort of conflict that requires legal intervention.
And so how did you first hear about the issues of books in Florida? Were you following the news, or was it you were involved just kind of once you became representative of these clients?
Well, I certainly been, following the general, beginnings of the waves of book banning. But I think I particularly, when this all began, was really paying attention to what's, now known as or has been dubbed the Don't Say Gay bill in Florida. As I said, I'm from Florida and my family is still there. And so that passage there of that law was certainly troublesome to me and something that I was following. And a lot of the book restrictions and bannings we've seen, at least initially, stemmed from the passage of that law.
And so I think what's interesting, and some other people have pointed this out, but some of the books that have been on this targeted list and removed from shelves, things like The Kite Runner or The Diary of Anne Frank, were actually required reading at one time in some Florida classrooms.
Yeah, I mean, a lot of the books, even including the 36th issue in my case, were written by or literary luminaries, and are books that, until recently, I think people thought were, very important aspect of anyone's education, whether you're, a student, a child, or an adult. So certainly, when I'm in conversation with lots of people about the rash of book restrictions and bannings we've seen, people are often really surprised by the books that are listed in these banning cases.
And so you have other clients, other pending cases. Can you give us some sense as to the larger picture in Florida or in the country right now in terms of where cases like this stand?
I mean, I guess what I would say is, there are several book censorship cases being litigated throughout the country. Litigation, for better or for worse, is often a slow process. So the majority of the cases are still in their very beginning stages. And as a result, the law is really kind of, just beginning really to develop around these issues. And in part, that's because this wave of book censorship is somewhat new to us. This is not something our country has been known for. And so while there certainly are, legal case law and guardrails in place, there are new kind of instances coming up that, courts haven't quite seen exactly before. And so the battle is ongoing, and this settlement is just, one marker, one moment in that battle. I think it's an important moment because it sends several messages about what is and is not appropriate or legal to do with respect to book challenges and book censorship. But it's certainly an ongoing process.
So I want to note that the Nassau County chapter of Citizens Defending Freedom, which was the group that initially lobbied to have these books removed, has said it is disappointed by this settlement agreement. The executive director of that organization in Nassau County called it a dark day for Nassau County schools. And he said that He has also asked the governor to step in, to remove the school board, to remove the superintendent in Nassau County, and also notified the Nassau County sheriff, um, quote, that they are distributing materials in violation of Florida's child obscenity laws. What, if any, involvement would you have in negotiating those complaints that have been filed either with the governor or with the sheriff's office? Can you give us some sense as to what we could anticipate from those complaints?
I cannot. I'm not involved in that, and I certainly can't anticipate how I guess Florida officials will react to a settlement, by the way, that was also reached in the Sunshine pursuant to Florida Sunshine rules in terms of the ability of the defendants and the school board to enter the settlement agreement.
And I know you say that the settlement includes this statement, that there was no obscene material in Tango Makes Three, and that these other books were deemed appropriate for, students to access. But Florida has broadened its definition of, forbidden sexual content in statute. Did that statute come into play when you were reaching this legal settlement with the school district? Like, was that the law at issue that they were basing their claims on?
Yeah, my understanding is the challenge was based on the obscenity statute. So that kind of broadened definition that was included. But even then, I mean, the law doesn't say, if there's still an analysis that has to be done of each material, of each book, and you have to look at the book and the material within the book, and as a whole, just because there might be one mention of a sexual act that might not be sufficient under the obscenity statute to remove the book. But yes, that is what the special interest group cited as their basis. And we discussed in our complaint how kind of these evolving laws in Florida and across the country have led to people filing challenges of books based on those laws, whether they're reading the laws rightly or wrongly. That's, I think, for the local officials, that's really in their hands to determine.
We've got a call from Ricky on the north side. Good morning, Ricky. Go ahead.
Yeah, I was going to ask how the opinion of the governor and the legislature took that as the action of the removal of those books and then putting them, and then now allowing them to go back on the shelf. In other words, is the governor in favor of those committees taking those books out of the school library and now out of the public library? That's my question.
Whether the governor favors it. Lauren, do you have thoughts about that?
Sorry, the question was whether the governor favors the removal of books.
Mm-hmm.
I mean, I can't really speak to what the governor favors, and I don't know if he has any opinion, particularly with what happened in Nassau. But I think we can say that the Florida legislature has created laws through which books and school materials can be challenged.
Is there anything instructive in this settlement agreement that you reached for other school districts that are involved in these challenges, or does it send any message to other Florida counties?
Yeah, I think there are kind of several messages and lines in the sand that the settlement draws. First, it establishes that special interest groups should not and cannot make the decision for what students in a particular school district or really anywhere should be reading. That's not a decision that should be made by special interest groups. It also speaks to the dangers of serial filings, which we're seeing across the country, where one group or one person, regardless of whether they're a community member or have a child in the district, file, large swaths of book challenges, and the importance of looking at those book challenges and not accepting them whole cloth, particularly when they come from, what is being termed as a serial filer. The other really important item, as I kind of mentioned at the beginning, is that pretextual reasons for removing books or violating authors and students and parents' First Amendment rights won't be countenanced. There has to be a legitimate reason for censoring a book, and pointing to, pretextual reasons is not going to fly, for lack of a better way of putting it. And this lack of circulation leading, pretext that was used in Nassau has been used in other places. It was recently used in a case in the Fifth Circuit that, at least at the initial stages, the Fifth Circuit has rejected. So, each time a new pretextual reason is used, I think it serves as a warning that it will be challenged. And if it can't be supported under the facts, hopefully the books will be restored.
Well, Lauren Zimmerman, thank you so much for joining us today for this conversation. We really appreciate it.
Thank you so much for having me and for spending time on this issue.
Absolutely.